Welcome to this explainer. I'm really excited to guide you through today's topic because we're unpacking a fascinating Supreme Court case that honestly sounds like it was pulled straight out of a legal thriller. We're going to look at how a massive drug conviction, a full-on life sentence, completely unraveled over what seems like a really minor geographical detail. It's an absolute masterclass and why the fine print of the law matters to every single one of us. Let's get right into it. So you might be wondering, how exactly does a seemingly open and shut drug bust end up as a Supreme Court acquittal? Well, to understand how a rock-solid case just collapses like a house of cards, we really need to trace the steps of law enforcement and find the exact moment they stepped out of bounds. Okay, let's start with the facts. It all kicks off in July 2013. The Philippine Drug Enforcement Agency, or PDEA as we'll call them, got a tip from a confidential informant about illegal drug sales happening at the home of a guy named Rule Aligaban in Legazpi City. So the agents did their thing, right? They ran casing, surveillance, even executed some test buys. And based on all that, they applied for search warrant number 2013-48, which was officially issued on July 29th. Literally the very next afternoon, July 30th, the agents raid Aligaban's place. After a quick scuffle at the back door, they secure the house and start their search. And that search led to a very specific number, 11.989. That's the exact amount in grams of methamphetamine hydrochloride, locally known as shabu, that agents allegedly seized from a black pouch inside one of the bedrooms. Now, in the eyes of the law, seizing more than 10 grams of this stuff carries some incredibly severe consequences. To put it into perspective, this specific amount landed the accused a staggering sentence, life imprisonment plus a 500,000 peso fine. So at first glance, the state absolutely had their man. They had the evidence to put him away forever. Section 1. A question of geography. Now, here is where things get super interesting. We've got a glaring geographical discrepancy. On one hand, we have Legazpi City. That's where Aligaban lived, where the alleged drug sales took place, and where the raid actually occurred. But then, on the other hand, we have Ligao City. That's where the PDEA agents inexplicably went to apply for their search warrant and where a judge ultimately issued it. So why on earth would law enforcement bypass their local courts and drive to a completely different city just to get a warrant? Section 2. The search warrant rules. To figure that out, we need to look at Rule 126, Section 2 of the Revised Rules of Criminal Procedure. The law establishes a pretty strict venue rule. The general rule is clear. You got to file the application in the court where the crime was actually committed. So for this case, that meant Legazpi City, no question. But as with everything in law, there's an exception. You can file in another court within the same judicial region, and this is a huge but, only if you state compelling reasons in the application. Section 3, defining compelling reasons. So, what exactly counts as a compelling reason? Well, if we look back at past rulings, a really clear pattern emerges. Take the 1994 Malaloan case. The court said, sure, applying outside the jurisdiction is okay if it's justified by compelling considerations of urgency, subject, time, or place. Then jump to the 2004 Tu case. Law enforcement applied elsewhere because they were afraid information would leak to the suspect. The court allowed it, but, and you really got to pay attention to this, they only allowed it because the agents provided actual evidence on the record that the suspect had a second residence where he could stash the drugs. And finally, in Pilipinas Shell in 2015, the court hammered home that stating these compelling reasons isn't just some optional bureaucratic step. It is absolutely mandatory for the application to even be considered. Long story short, the courts have consistently demanded actual, hard evidence to justify skipping out on the local court. Knowing all that, how do you think the PDEA justified going to Ligao City in our case? Well, they wrote this single sentence in their application. To prevent and/or preempt any leakage of information relative to the application and/or implementation of the search warrant. And that's it. That is literally the whole shebang. No extra evidence, no proof of corrupt local officials tipping people off, no specific facts whatsoever. They basically just used a vague, copy-pasted blanket statement to justify driving to a whole other city for what looks like a convenient rubber stamp. And this brilliantly illustrates why the PDEA's unsubstantiated claim completely falls apart. You see, a judge cannot just issue a warrant based on a hunch or mere guesswork. There has to be a substantial basis. In legal terms, that means there must be particular facts and circumstances on the record examined by the judge that would make a prudent person believe an offense actually occurred and that a warrant is justified. The Supreme Court pointed out that lower courts had actually started misinterpreting these rules, kind of treating a simple, copy-pasted claim of "we fear a leak" as an automatically valid, compelling reason, and they were doing it without requiring a single shred of actual proof. Section 4, the Supreme Court's verdict. Okay, before even ruling on the drugs themselves, the court really hammered home the constitutional stakes here, pulling straight from Article 3, Section 2 of the Constitution. It states that the right against unreasonable searches and seizures is inviolable. A search warrant can only be issued upon probable cause, and that has to be determined personally by a judge. The Supreme Court essentially reminded us that these venue rules for warrant applications aren't just annoying red tape. They are vital procedural safeguards tied directly to our constitutional guarantees. Bypassing these rules without solid proof is a massive deal. It actively threatens our fundamental rights against state overreach. So applying those high constitutional standards to the PDEA's actions, the Supreme Court completely dismantled this search warrant, piece by piece. First off, the agents provided zero evidence of a potential information leak on the record. None. They also drew no connections between Alagaban and specific groups in Legazpi City that could even facilitate a leak. The entire application was based on mere generalizations and legal conclusions, totally lacking any personal knowledge from the applicants themselves. The highest court in the land made it crystal clear. Unsubstantiated fears do not equal compelling reasons, which means the judge in Legazpi had absolutely no substantial basis to issue the warrant in the first place. And the domino effect of that ruling? It was absolute. Because the warrant was issued without compelling reasons, it blatantly violated both the rules of criminal procedure and the Constitution itself. So the search warrant was declared completely invalid. And because the warrant was invalid, the raid was illegal. That meant the 11.989 grams of shabu were totally excluded as evidence. It's what the law famously calls the fruit of the poisonous tree. Without those drugs on the record, the state had zero evidence to prove a crime even happened. The life sentence was overturned and Rel Alagaban was completely acquitted and ordered to be released. Ultimately, what you should take away from this explainer is this. Procedural rules, like specifically which city a police officer has to drive to just to get a piece of paper signed, they aren't just bureaucratic suggestions. They are literally the bedrock of constitutional freedom that shields every single citizen from state overreach. These rules exist for one big reason: to force the government to prove they actually have the right to kick down your door. Think about it. If we allow the state to cut corners on the very rules meant to restrict them, just because it's convenient for them, whose door might they unlawfully knock on next?